Hello viewers, quasi contracts. Technically speaking, these are no contracts at all. Then why they are termed as quasi contracts? Because the obligations which arise out of certain events, they are in the nature of contractual obligations. And therefore, they are termed as quasi contracts. Often, they are also termed as implied contracts. The provisions with regard to such obligations are found in section 68 to 72 of the Indian Contract Act. Mind well, these obligations have their roots in equity and are based on the doctrine of no unjust enrichment. Section 68 of the Contract Act prescribes this. And what does it say? If a person incapable of entering into contract. Please see the wording. Person incapable of entering into a contract means person who cannot enter into contract. Therefore, essentially, you will have to look to section 11 of the Contract Act, which says that persons who are competent to contract. Section further says, or anyone whom he is legally bound to support, means the dependents of the incapable. So both person incapable as well as dependents of incapable is supplied by another person with necessaries suited to his condition in life. The person who has furnished such supplies is entitled to be reimbursed from the property of such incapable person. We'll see the analysis of the section. The statutory illustration given in the section itself is about a lunatic who is supplied necessaries. B illustration says about the dependence of the incapable lunatic. Mind well, this section makes provision for necessaries supplied to incapable and reimbursement to the supplier. One who is incapable, one who cannot enter into contract, like minor, lunatic, person who is disqualified by law, like insolvent. If such persons are supplied with necessaries, yes, the supplier is entitled to recover the same from the estate of the person incapable. It serves dual purpose, that is, welfare of incapable and protection to the supplier of necessaries. Mind well, there must be supply of necessaries. Now, what is necessaries is not prescribed by law. It varies depending upon the station in life of the person incapable. Mind well, mere food, clothing, and shelter are not the necessaries. Whatever is the station of life of the incapable, what does he need? decides the necessaries. I may simply tell you that a Mercedes may be a necessity and a cycle may be a luxury. Therefore, whether it is a necessaries or not depends upon the facts and circumstances of each case. But remember that whatever is supplied must be necessaries. If it is not a necessaries, the protection of this section is not available. And the supplier, what is his protection? That he is entitled to recover whatever is supplied as necessaries from the estates of the incapable. Meaning thereby, there is no personal liability. Obviously, because we say that he is a person not capable to enter into contract. Therefore, he cannot create a contractual liability. He cannot create a personal liability. Now, section 69 speaks of reimbursement. Reimbursement of what? Look at the section. A person who is interested in the payment of money which another is bound by law to pay, and who therefore pays it, is entitled to be reimbursed by the other. Look at the wonderful design of the section. One person is interested in the payment of money. The other is bound to make the payment in law. But he doesn't pay. And therefore, the person interested in payment makes the payment. What would be the result? Has he to lose the money? The answer is no. Law says, yes, he is entitled to be reimbursed by the other. Means the person liable to make the payment. Look at the illustration given in the section itself, which is for the lease grant and the payment of revenue, which says that if the person interested pays, is entitled to recover. Mind well, this section speaks of the reimbursement. Reimbursement means return of the actual amount spent. And what is required for this? Most important thing is there must be a legal liability of one, say the landlord. The other must have an interest in the payment of such liability, the tenant. The most common example of this can be had in rented property. As you all know, property tax is levied by the civic authorities. The landlord, in order to get eviction or to harass the tenant, does not pay the municipal taxes, though he is liable to make the payment. In such situation, the civic authorities take coercive measures. In order to avoid such coercive measures, the tenant who is interested in possession is equally interested in payment of taxes and makes the payment in order to avoid the coercive action. Section 69 says that the tenant is entitled to be reimbursed for the tax amount paid by him. Section 70 makes provision for liability for non-gratuitous act. Non-gratuitous act means not free. Section says where a person lawfully does anything for another or delivers anything to him, not intending to do so gratuitously, and such other person enjoys the benefit thereof. The latter is bound to make compensation to the former in respect of or to restore the thing so done or delivered. Mind well, section protects non-gratuitous act. There may not be formal contract. At the same time, one doesn't render service or supply goods free of cost gratuitously. In such situation, if the person who has enjoyed the benefit, can he say that there was no contract and therefore I am not liable to make the payment? Law says no. If the service rendered or goods supplied are non-gratuitous, then one is entitled to be restored the same thing delivered or compensated for services enjoyed. The section itself gives the illustration of delivering goods to someone's house through mistake. Law clearly says the person at whose house, B's house, where goods are delivered through mistake, enjoys the goods, is bound to make the payment for the goods. This section makes special provision about the responsibility of finder of goods. Often we find goods but not the owner. What is the situation in such cases? Section 71 of the Contract Act says a person who finds goods belonging to another and takes them into his custody is subject to the same responsibility as a bailee. Now, what is bailee? We'll see later on. The most common example of bailee is, say, laundry, where we give our clothes for washing. It's a contract of bailment. There are duties of bailee. Most important of them are to protect and preserve the goods, take care of it, and find the owner of the goods. That position is given to the person who finds the goods of another. Therefore, this section specifies the position of a finder of goods. The same rights and duties of a bailee are the rights and duties of the finder of goods. Look here, section 72 speaks of liability in case of mistake or coercion. And what does it say? A person to whom money has been paid or anything delivered by mistake or under coercion must repay or return it. The section itself gives illustrations, but in simple parlance, you can say that if anything is supplied through mistake, like earlier one, or coercion you know under the Contract Act, where any force is applied. In such situation, the person who has delivered the goods or money, yes, is entitled to be repaid. You can very well visualize the equity demands that you cannot enjoy somebody else's mistake if you have taken the advantage of it. You cannot coerce someone and then don't pay. If you have obtained it under coercion, then also you are bound to make the payment of the goods enjoyed.